Good day, everyone! Our topic for today is all about Law of Partnership, Article 1795 to 1805.
Article 1795 states that the risk of specific and determinate things which are not fungible. When we say fungible, it means interchangeable or replaceable. So, ang sabi dito, which are not fungible. So, it basically coincides to the concept of specific and determinate things not interchangeable, not irreplaceable. So, ulitin natin. The risk of specific and determinate things which are not fungible contributed to the partnership so that only their uses and fruits may be for the common benefit shall be borne by the partner who owns them. So basically, this falls under the concept of universal partnership of profits, wherein the contribution of the partners in the partnership is not the ownership of the properties, but rather their usufruct, the right to enjoy their usage. Which in this case, ang sabi, the one that will be contributed to the partnership is the usufruct, the right to use and their fruits of the specific or determinate things. Ang sabi dito, yung magbubor ng risk over those things will be the partner who owns them. Kasi hindi naman niya transfer yung ownership to the partnership. Ang transfer niya lang ang usufruct, the right to use, but the ownership still stays with the partnership. Now, if the things contributed are fungible, meaning they are irreplaceable, interchangeable, or cannot be kept without deteriorating. Examples nito are fruits, vegetables, foods, because they are deteriorating, they are highly consumable. Or if they were contributed to be sold, inventory, the risk shall be borne by the partnership. Now, in the absence of stipulation, the risk of things brought and appraised in the inventory shall also be borne by the partnership, and in such case, the claim shall be limited to the value at which they were appraised. In order for us to fully understand Article 1795, we created a table bearing the risk of loss of things contributed. So in the first column, we have the different scenarios, and in the second are those who will bear the risk of loss. The first one is the specific and determinate things which are not fungible. In this case, the usufruct is the only thing contributed by the partner. So as stated, the risk is borne by the partner kasi hindi niya transfer ang ownership. Ang transfer niya lang ang usufruct. For the second scenario, specific and determinate things, the ownership of which is transferred to the partnership. In this case, the usufruct and the ownership of the item are transferred, which is the specific and determinate things. The ownership of such is transferred to the partnership. Thus, the partnership will bear the risk of loss. Next, fungible things, or those things contributed that are consumable, things contributed to be sold, and things brought and appraised in the inventory as provided by second paragraph. The risk is borne by the partnership. It was already transferred to the partnership, so the partner no longer own it, and he cannot get anything from it kahit bawiin man niya ito because it is deteriorating. It is consumable. Hence, the risk is borne by the partnership. Unlike the specific and determinate things, kung babawiin niya, magagamit pa niya yon. So that's the point of Article 1795, kung sino yung magbe-bear ng risk of loss at different scenarios.
The Article 1796, the partnership shall be responsible to every partner for the amounts he may have disbursed on behalf of the partnership and for the corresponding interest. From the time the expenses are made, it shall also answer to each partner for the obligation he may have contracted in good faith in the interest of the partnership business, and for the rest in consequence of its management. In the absence of any stipulation, every partner is an agent of the partnership for the purpose of its business. Responsibility to partners. To refund the amount disbursed by partner in behalf of partnership, plus corresponding interest from the time the expenses are made. Loans and advances made by partner to the partnership aside from capital contribution. To answer for obligations a partner may have contracted in good faith in the interest of the partnership business. to answer for risk in consequence of its management. This article is all about the partner's partnership obligation and responsibility. It is created because each of the partners has a separate and distinct legal entity. Because each partner is a separate and distinct entity from the others, the partnership should have an obligation to the partners. Responsibility of the partnership to a partner. Partners are considered as the partnership's agents despite the fact that partnership is merely a designation. Finally, it is the partners and partnership's mutual benefits that matter. Because the partnership benefits, it is up to them to take the responsibility and the risk. The legal entity of a partnership is distinct. As a result, Article 1796 focuses on the partner's responsibilities and obligations. That is, the partnership is beneficial to the partner's actions. Example for risk management. A partnership is engaged in selling goods and a customer keeps asking for discounts and an argument ensues or follow between the customer, C, and the partner, A. A gets injured and is brought to the hospital. Who shall shoulder the hospital bills? The partnership shall shoulder the hospital bills as it was during A's time in managing the business that he was injured. The risk happens presents how the partnership shoulders the risk. Obligations of the partnership. To reimburse any amount disbursed by the partners in behalf of the partnership. Example, a partnership borrows from the bank a sum of 10,000 pesos for additional funds but cannot pay it back when it is due to be paid back. A pays back the 10,000 using his personal funds. Should he be reimbursed by the partnership? Yes, the partnership should reimburse A for the sum of 10,000 plus legal interest starting from the date A disbursed the 10,000. This shows the obligation of partnership to the partners.
Article 1797 basically talks about distribution of profits and losses. As stated in the article, the profits and losses shall be distributed in conformity with the agreement. If only the share of each partner in the profits has been agreed upon, the share of each in the losses shall be in the same proportion. In the absence of stipulation, the share of each partner in the profits and losses shall be in proportion to what he may have contributed, but the industrial partner shall not be liable for the losses. As for the profits, the industrial partner shall receive such share as may be just and equitable under the circumstances. If besides his services he has contributed capital, he shall also receive a share in the profits in proportion to his capital. The rules for distribution of profits and losses. When the partnership has an agreement, the distribution of profits is according to agreement, and for the losses also it is according to agreement. And if the partnership has no agreement or without agreement, the the distribution of profits is that it looks like this. First, share of capitalist partner is in proportion to his capital contribution. And the second, share of industrial partner is not fixed as may be just and equitable under the circumstances. And for the distribution of losses without agreement, if sharing of profits stipulated, apply to sharing losses. And second, if no profit sharing stipulated, losses shall be borne according to capital contribution. And lastly, purely industrial partner not liable for losses because the industrial partner contributed labor, work, and service. It has been done, so he is not liable for losses. But if there is a capitalist industrial partner receive loss but only as to the proportion of his contribution, being a capitalist partner. Being industrialist, he does not receive any loss. He will only receive loss on his part being a capitalist partner. That is, if there is a capitalist industrial partner.
Article 1798. If the partners have agreed to entrust to a third person the designation of share of each one in the profits and losses, such designation may be impugned only when it is manifestly inequitable. In no case may a partner who has begun to execute the decision of the third person or who has not impugned the same within a period of 3 months from the time he had knowledge thereof complain of such decision. The designation of profits and losses cannot be entrusted to one of the partners. So it means both partners have agreed instead na sila ang mag-designate or give stipulation if magkano ang ilang bahinon, they both decided to entrust to a third person unrelated to partnership. Of course, not the partner. Siya ang mag-decide if how much is the share, the profit and losses sa mga partners. Then, the third person will going to designate on it. If what the third person designate, it will be final. The designation of the third person can only be impugned, means to question the validity or question the truth. The designation of the third person can only be impugned, pwede mo lang i-question yung validity kapag if it is manifestly inequitable, if it is unfair of the designation of shares by the third person, then doon mo lang siya pwede i-question. So, a partner who has begun to execute the designation of the third person may no longer complain if he did not impugn the same within the allowed period. So, in this article, it talks about designation or distribution or determination of the profits and losses of the partners.
Article 1799. A stipulation which excludes one or more partners from any share in the profits or losses is void. The law does not allow a provision in the contract of partnership excluding one or more partners from sharing in the profits and losses. The reason is that a partnership is organized for the common benefit or interest of the partners. Reason for exclusion of industrial partner: an industrial partner is not liable for losses because if the partnership fails to realize any profits, the industrial partner would have contributed his labor in vain. Example: A, B, and C are partners with the following capital contributions: 30,000, 20,000, and 10,000 respectively, where C is capitalist industrialist partner. For 1 year of their operations, their partnership had earned net profits of 17,000. How shall these profits be divided among the partners? C is entitled to receive 2,000 out of the entire 17,000. In accordance with any existing agreement between the partners as to how they shall share. If there was no agreement, then the partners shall share on a pro-rate basis. The industrial partner shall get what is just and equitable in the circumstances. So, bonus na ni siya to the partner. The same rule shall apply for losses in the partner's operations. However, the industrial partner shall not share in the losses as there is no way for him to retract his industry and in the event of losses. His efforts would have been for vain and it can thus be said that he has already shared. Article 1800s. The partner who has been appointed manager in the articles of partnership may execute all acts of administration despite the opposition of his partners, unless he should act in bad faith, and his powers is irrevocable without just or lawful cause. The vote of the partners representing the controlling interest shall be necessary for such revocation of power. A power granted after the partnership has been constituted may be revoked anytime.
Appointed during the constitution of the partnership may execute all administrative acts unless he acted in bad faith. His power may not be revoked unless there is a just and lawful cause and the vote of the partners will controlling interest. Even if their objection as to his decisions coming from the partners, his authority will prevail unless he has acted in bad faith. Acts of administration, ordinary business, and administrative transactions, because if you revoke his power, you are in effect changing in the terms of the contract of the partnership.
Appointed after the constitution of the partnership, may have his power revoked or cancelled with or without cause, decided upon by those partners who own controlling interest in the partnership.
Article 1801. If two or more partners have been entrusted with the management of the partnership without the specification of their respective duties or without the stipulation that one of them shall not act without the consent of all others, each one separately execute all acts of administration, but if any one of them should oppose the act of each other, the decision of the majority shall prevail. In the case of a tie, the partners owning the controlling interest shall decide the matter, where respective duties of two or more managing partners not specified. This article is about the appointed managing partner of the partnership. Two or more partners, but these are based on the agreement of the partnership. These managers have no specification of their respective duties unless they want to stipulate something, but of course with the consent of all partners before they act. In making decision, the concurrence of all is necessary for the validity of acts. In short, they cannot act without the consent of all partners. In case of a tie, the partners will be based on the partners owning the controlling interest of the partnership. Whoever has the most interest in them will be the manager.
Example, assume that A, B, C, and D are all managing partners. A appoints E as a secretary, but B objects to this. Is the appointment of E valid? Yes, says majority votes are first counted by head. If C and D were the ones to object, and they owned a combined total of 51% of the partnership interest, then the appointment will not be valid. However, if B is still the one objective and he owns 51% in the partnership interest, the appointment will still be valid because majority votes are first counted by head. If the partnership cannot make a decision and ends up in a tie, both head counts and interest, then the partnership is to be dissolved. This will be the only remedy unless one of the other partners will relent.
Article 1802. In case it should have been stipulated that none of the managing partners shall act without the consent of the others, the concurrence of all shall be necessary for validity of the acts, and absence of disability of any one of them cannot allege, unless there is imminent danger of grave, of irreparable injury to the partnership. This is a case wherein two partners, A and B, stipulate that none cannot act without the consent of the other. Thus, there must always be concurrence between the two before any transactions may be entered into. The absence of the other's consent shall not be used as the excuse.
For example, A and B are in a partnership where they sell fruits. B notices that the fruits in the warehouse are starting to rot, so, without consent of A, he sells them. This will be alright because if the fruits rot, then it would have been bad on the part of the partnership.
Article 1803. When the manner of management has not agreed upon, the following rules shall observe. First, all partners shall be considered agents, and whatever any one of them may do alone shall bind the partnership without prejudice to the provision of Article 1801. Second, none of the partners may, without the consent of others, make any important alteration in the immovable property of the partnership, even if it may be useful to the partnership. But if there is refusal of the consent by the other partners is manifestly prejudicial to the interest of the partnership, the court's intervention may be sought. In Article 1803, unanimous consent required for alteration of immovable property. So why is it in movable property only and not movable property? It is because immovable property has a big responsibility or has a high degree of responsibility and obligation on immovable properties or entailed in owning that immovable property. And if refusal of partner is manifestly prejudicial to interest of partnership, court's intervention may be sought. For example, if you want to improve or alter immovable property, you can only do that if you have the consent by other partner, even if it may be useful to the partnership. Now, if there is a refusal by partner, and you have determined that it is manifestly prejudicial to the interest of the partnership, like there is no proper basis on the refusal of partner in altering the property, then you can go to the court and ask for intervention. Or you can force him to agree to alter the immovable property through the court. But what if it is for the preservation of immovable property? Does it need the consent of other partners? The answer would be no. You don't, because we are not talking about the improvements to the immovable property. Because when it comes to improvements, you need consent, or if it is manifestly prejudicial in refusal, court's intervention may be sought. But now we are talking about the preservation of the immovable property. They can be perished or it has imminent danger that it can be lost. Now, because it is for an act of preservation, even there is no consent by other partners, it is still can be done. You can have actions in order to preserve the immovable property. But take note that it is only for preservation of the immovable property so that it will not be perished.
Article 1804. Every partner may associate another person with him in his share, but the associate shall not admit it into partnership without the consent of all other partners, even if the partners having an associate should be a manager. In this article, the partner is making another partnership, and that is called sub-partnership. Sub-partnership is a partnership within the partnership and don't have an effect to the original partnership. Sharing of profits in individual capacity. For example, E is making another contract with Z, so Z is the associate person. If A receives his profit, then Z has a share of it. From that contract, Z become a sub-partner. Sub-partner again is a partnership within the partnership. But such sub-partnership has no effect on the original partnership. It is only sharing of profits of A in his individual capacity. Even there is no consent of other partners that Z will be part of the partnership, even if A is a manager, then it cannot be. So it only shares the partnership profits from the partnership of A and Z. That is why shall not be admitted into the partnership without the consent of all other partners, even if the partners having an associate should be a manager.
Article 1805. The partnership books shall be kept subject to any agreement between the partners at the principal place of the business of the partnership, and every partner shall at any reasonable hour have access to and may inspect and copy any of them. Of course, they have the owner of the business, so they have the right to inspect the book of the business, but of course, there are requirements when they go to the principal place of business, and they can only check it at any reasonable hours of the day to access and copy the book, because that is the right as owners of the business. They can only use it with partnership purposes. When will the partner be allowed to access the partnership book? The partner is allowed to access partnership books during reasonable hours and days of business, like 8 a.m. to 5 p.m. or Monday to Friday, according to the law. The one who is keeping the partnership books cannot state when they can be inspected.
Thank you everyone for having your time with us. Stay safe!
This is Nelyn Ebarat,
Lovely and Magtrayo,
Rammie Jr. A. Magtrayo,
Regine Cantero,
Almae B. Lascuña,
Regine C. Bartolome,
Crizel Gwen Sarvida reporting.